Michael, you're muted.
Good afternoon, everybody. We'll try this again. I'm Michael Scharf. I'm the co-dean of the law school, and I'm here together with Jessica Berg, the other co-dean, and we welcome you to the celebration of Maury Shanker's life and works. This is not a memorial, as Maury would have wanted it. It is a true celebration. And we are very happy that his daughter Jamie is with us, and she'll be speaking, and some of his closest friends and colleagues will also be joining us. I want to especially thank Sharona Hoffman, who's organized today's event, and she'll be serving as our moderator. Now, Maury taught here for 49 years, and next to Lou Katz, that was the longest any professor in the history of this institution. He served as acting dean, he won Teacher of the Year award, he was amazing. And he really loved the school, but I'll tell you one thing he didn't love: faculty meetings. In fact, we often end our faculty meetings like we did the one on Wednesday by saying, who is going to make Maury's motion? And that was the motion, of course, to adjourn, so he could get out of there and get back to his writing and teaching. Maury did something incredibly generous to help ensure that in the future, we'll be able to attract and retain great teachers and scholars just like him. And I'm going to turn it over to Dean Jessica Berg to tell you more about that. Thank you for joining us today.
So I have the great pleasure to announce that Maury has left us an incredible gift of $2 million to endow the Morris G. Shanker Professorship in Law. It's just an extraordinary, generous gift from him. And I have to say, I am completely tickled that we will have his name remain as a professorship and associated with professors in perpetuity. So again, thank you so very much to Maury. Thank you to his daughter, Jamie, who's helped us coordinate on this. And we're just absolutely thrilled with the generosity and the thoughtfulness of the gift.
This, in fact, is the first chaired professorship we've had in about a decade. It's really a rare occasion and a superb contribution to the life of our school. Now, let me turn it over to Sharona Hoffman, who is going to serve as the Master of Ceremonies for the rest of this event. Sharona? Now you're muted. Same thing.
Thanks so much, Michael. And it is just such a pleasure that Maury left us this gift, and we will appreciate him and remember him forever now at the law school. So I'm Sharona Hoffman. I'm a professor of law and bioethics at the law school. And although Maury was my colleague here at Case Western Reserve University, I feel that my connection with him was more personal than professional. I don't know anything about his areas of expertise, and I'm hoping never to know anything about bankruptcy. I got to know Maury well because of my father, may he rest in peace. When I moved to Cleveland from Houston in 1999, the Cleveland Jewish News did a nice story about me. I guess back then it was newsworthy if someone actually moved to Cleveland. This article talked about my job, my background, and my parents. My father's roots were actually in Cleveland. A few days after the story was published, Maury came to my office and stood in the doorway and stared at me. I was terrified. I was newly on tenure track, and here is a very senior faculty member standing and staring at me. What had I managed already to do wrong? Finally, Maury said, "Yes, I can see it now. You really are Morty Hoffman's daughter." It turned out that Maury and my father went to Glenville High School together here in Cleveland. That created a bond between us that lasted throughout the rest of Maury's life. When I told my father that I was working with Maury Shanker, he was so excited. He exclaimed, "Oh, wow, Maury was my boyfriend." I had to explain that nowadays that word had certain implications that I didn't think applied, but clearly they were good friends. A particularly memorable day was the day Maury told me that we were going to leave the law school in the afternoon and go on an excursion. He said we were going to see the house in which my father grew up, which he remembered well. I couldn't believe it. Maury and my father grew up during the Depression in the 105th Street area, very close to the law school. In an effort to make his daughters appreciate all that they had, my father talked nonstop about how impoverished his family was and what deprivations he had suffered growing up. I was certain that his house had crumbled to dust long ago. Maury easily found the house and showed me that that was not the case. It was a pretty good house. My father lost a little bit of credibility there. Thanks to Maury, I was able to take my father to see his old house when my parents next traveled from Michigan to Cleveland for a visit. He even knocked on the door and spoke briefly with the woman who lived there. And that woman remembered her father buying the house from my grandfather. Maury and I spoke often while he continued to work at the law school and saw each other in synagogue while he was still able to attend. We both belonged to Bethel the Heights Synagogue in Cleveland Heights. He used to arrive even later than I did, as close as possible to the post-services luncheon, to the Kiddush lunch. I spent many happy hours in the Shankers' home at Yom Kippur break the fasts, New Year's Eve, New Year's parties, cat birthday parties, and more. Brondy's food was always plentiful and delicious. After Maury moved to Stone Garden, I visited him there, though not often enough, as he always pointed out. Maury told me many, many stories about his childhood and the life he lived when he was growing up in the neighborhood he shared with my father. And after telling me I needed to visit more frequently, he would always ask for a hug and say that he loved me. I really miss him. Now we are going to hear from Dr. Jamie Shanker, who is Maury Shanker's daughter.
Good afternoon. Can everyone hear me okay?
Yes.
Okay, so good afternoon. I would first like to thank the law school and specifically Professor Sharona Hoffman for arranging this lovely celebration. I was going to say memory, but we'll say celebration of my father. I know he would be so honored and grateful. I would like to say a few words about my father's early life, which may not be so well known to those in attendance today, although Sharona said a few words already about that. His parents were Ukrainian or Polish, apparently depending on where the border was on any given day. They emigrated to the United States early in their marriage, and my dad, their youngest child, was born in Cleveland. When my father was just 2 years old, his father disappeared from the family in what I now believe was one of several bipolar manic episodes, leaving my grandmother and her 3 small children. They lived in the Glenville area, as you have heard, of Cleveland in a 1-bedroom apartment. My dad and his brother slept on a board placed between 2 chairs in the living room, while his sister and mother shared the bed in the bedroom. They were very poor. His mother, who did not speak English, plucked the feathers from slaughtered chickens to support her family. Having no father and a constantly working, low-paid single mother, my father was effectively raised by his older sister. World War II broke out when my father was a teenager. A few years later, he was fortunate enough to pass the US military's cognitive test and physical exam given to graduating seniors at Glenville High School. This important success admitted him into a naval officer training program and opened a door for him into a much larger world than he had known. Without the Navy, it is possible that my father would never have gone to college. The Navy enrolled him into an electrical engineering program at Purdue University. However, the war ended before he completed his bachelor's degree. The GI Bill allowed him to finish his bachelor's degree in electrical engineering, but pretty quickly, my dad realized that engineering was not a good fit for him. So again, with the GI Bill, he decided to try business school at the University of Michigan. 1 year into that degree, he recognized that business did not fit him well either. Thus, using the GI Bill for the 3rd time, he enrolled at the University of Michigan School of Law. Finally, a good fit. My dad found the study of law to be enjoyable, intellectually stimulating, and rewarding. He blossomed. After law school, moving back to Cleveland, my father was excited to join a law firm, but it was another disappointment. He remained at that law firm for 9 mainly unhappy years. The practice of law simply did not suit him. He often told me that perhaps the most consequential day of his life was the day in 1961 when Western Reserve University invited him to be a professor at the School of Law. At long last, he found his ideal career. He loved legal teaching, writing, and thinking. He thrived in academia. It was the ultimate good fit for him, and he excelled at it for 49 years. Because the John Homer Cap chair supported my father's felicitous career, it was always his wish to pay that good luck forward and provide the same opportunity to another Case Western Reserve University law professor. My father would be delighted at this new beginning. Thank you.
Thanks so much, Jamie. We will now hear from Professor Eric Jensen, who is the Coleman P. Burke Professor Emeritus of Law.
Thank you, Sharona. This is in some ways a sad occasion, of course, but it's also wonderful to have a gathering, even a virtual one, of Maury's friends, colleagues, and students from over the many, many years. And it's wonderful to have the announcement of the new chair, an extraordinary gift from an extraordinary man. My family's connection with the Shankers goes back to our arrival in Cleveland in 1983. We lived about a block away from the Shankers. We saw them regularly for the bar and bat mitzvahs of Brondy's cats. Brondy tutored our daughter, Addie, before Addie made the move from a Montessori school to Shaker Heights High School. And both Brondy and Maury were supportive in so many ways. The psychological benefits were particularly pleasing. When we were in our 60s, Maury still referred to us as kids, even though we obviously weren't and aren't. The Shanker bloodline continues in our household. By way of Dr. Jamie, we inherited Brondy's cat, Gwen, short for Guinevere, one of several Shanker felines over the years with a Camelot connection. Others included Arthur and Lancelot. In the rest of my remarks, I'm going to crib from a piece I wrote 11 years ago for our law review on Maury's retirement after 49 years on the faculty. I'm sorry for repeating myself. I just have no imagination. And besides, Maury actually seemed to like what I wrote back then. Maury began teaching at the Western Reserve Law School shortly after the creation of the Western Reserve. Had Moses Cleveland not elbowed his way to the front of the boat in 1796, Maury might have been the first surveyor to step onto the banks of the Cuyahoga. If that had happened, the house band at Severance Hall today would be known as the Shanker Orchestra. Now, I'm just kidding, of course, but it does seem as though Maury, a native Clevelander, was a central part of this school forever. I've been here almost 38 years, and Maury was a grizzled veteran when I arrived. Generations of students and faculty benefited from his knowledge, erudition, and warmth. Maury was one of the foremost authorities on bankruptcy and commercial law in the nation and in the world. He was a visiting professor at some of America's greatest universities like Michigan and Berkeley, and he crossed the pond too to the University of London. He published widely and well in top journals. In 1964, one of his pieces appeared in the same issue of the Yale Law Journal as an article, The New Property, written by the flower child wannabe Charles Reich. Reich was best known as author of Kermit the Frog's favorite book, The Greening of America. Unlike Reich and Kermit, however, Maury generally resisted being greened, except when he was wearing one of his memorable iridescent suits. Maury's courses were always among the school's most significant and most popular. Maury knew more than anyone else about so many subjects. You didn't want to get him started on the statute of frauds if you had something else to do. And he conveyed that knowledge with conviction and enthusiasm. Maury had a forceful personality, as I learned from personal experience. I argued with him about statutory interpretation, the flat tax, equal protection clause, whether outfielders should bounce their throws into home plate, the merits of 20th century composer Alban Berg. Maury had been concertmaster of the University of Michigan Orchestra, and he had very strong views about the merits and demerits of most composers, and almost everything else imaginable. When he disagreed with me, Maury was wrong, of course, but his wrong-headedness made the arguments stimulating and great fun. Yeah, I don't mean to suggest that Maury was always a contrarian. As you've heard, he was a unifying voice on the faculty in at least one important respect, making the motion to adjourn faculty meetings. And adjournment is one issue on which all faculty, well, almost all faculty, can agree. Without Maury, faculty meetings could have routinely become Strom Thurmond-like filibusters. Of course, some of them came close to that anyway. Well, I can hear in Maury now. It's time for me to adjourn. Suffice it to say that I'm proud to have been Maury's colleague and friend, and I miss him dearly. Thank you.
Wonderful. Thanks so much, Professor Jensen. We now have comments from Mr. Marvin Sickerman, who is a bankruptcy lawyer in Cleveland.
Forgive me for the moment delay. I had unsilenced my mic. Sharona, first I want to thank you for giving me an opportunity to thank Maury publicly. Jamie, you and I don't know each other. It is a rare opportunity when someone can thank the child of someone who had an influence on your legal career. And that's what I'm going to do. My story with your father. It was during the first half of my senior year at law school. I was fall of 1958. I was law clerking for the late Joe Coy. We had mid-year classes in those years, which is why it was a first half different from today. One day, Joe Coy sent me to deliver a deposition notice to some guy, Maury Shanker, at this law firm that I knew nothing about, Grossman, Schlesinger, and Carter. I got there, told the receptionist I was here with some papers for Mr. Shanker. She came out and said, sit down and wait, I'll bring him here. I was flabbergasted. I thought I'd just leave the papers with the secretary and go. No, Maury came out to get the papers and immediately engaged me in a discussion. Who are you? Are you going, what school are you going to? Oh, that was a good school. What are you taking? And a lot of personal questions, which of course I answered. But I was shocked. Why is he engaging some law school student in a discussion? Bizarre to me. Little did I know that day would be the beginning of a long professional friendship. It seemed that Maury and I continuously started to cross paths. The year after I started practicing, Maury became a member of our school's faculty, a full-time professor teaching bankruptcy and commercial law, the exact area of law that I had become involved in. And what he did is he had taken over the bankruptcy course taught by the late Judge Carl Freebone. Judge Freebone, in those years, every other person was a referee in bankruptcy. He was a bankruptcy judge because he had been a judge of state court before being appointed to the bankruptcy bench. And our interaction as opposing counsel was very short-lived because Maury went to teach at the law school. Well, you know, get a friend, you think you got a mentor, and you lose him real quick. But it soon was apparent to me that there were problems that no matter how hard I researched, I couldn't find answers to. So I would call Maury with questions that were probably off the wall, like my favorite hypothetical. I wanted to know if a guarantor got released of the guaranteed claim if it had been paid by the person he accommodated, signing a guarantee for them, and they were discharged in a bankruptcy. I researched and researched. I came up empty-handed. Call Maury. Told him facts, gave him a question, and I got an answer sort of, well, it depends on a few facts, clarified the facts. He says, I think there's something in the restatement. I'll check it and get right back to you. Within a half hour, Maury called back to tell me the answers in the restatement of suretyship. The last place in the world I would have even thought of looking for it, and proceeded to give me a perfectly crystal clear answer. Or Maury, there's some discussion about trying to restart the Freebone College. Judge Freebone had died. Judge Freebone had, in addition to teaching the course at the law school, his activities both on the bench as a bankruptcy referee and his involvement with the National Association of Bankruptcy Referees, now the National Association of Bankruptcy Judges, had a rather full plate, but he managed to teach a course every Thursday night to practicing attorneys who pay a few dollars to learn bankruptcy law at basically the feet of a master. And by the way, when Maury was working on some bankruptcy law reform in the 1970s, Judge Freebone was one of his primary sources. So I figured Maury's not going to turn me down. And I was told, you know, let's get Freebone College started again. And that was the purpose of a call to Maury. I was sure he would say yes. I told him they asked me to consider teaching, and I didn't think I was capable of it. We wouldn't even know where to start. So, you know, Maury, it was too subtle, I guess, or maybe I wasn't subtle enough, because the answer was, I'll be glad to share my syllabus with you. I'll be glad to give you all the help I can, but you ought to do it, not me. That's the typical Maury I knew. And by the way, till the day he retired, I knew where to go when I couldn't find an answer. And there were many a call of that type. With that, Jamie, thank you for sharing your father.
Thank you so much, Marvin. Now, Professor Bill Leatherberry, he's a professor emeritus of law.
Thank you, Sharona. I'm honored and pleased to be part of the celebration of the life and achievements of Professor Shanker. The photo behind me is the old law school building, the main section. It now houses the University Health Service. The other part of the building, which housed the moot courtroom and the library, was demolished many years ago. Professor Shanker joined the faculty in 1961, the year before the Uniform Commercial Code the UCC, was enacted in Ohio. He quickly became known as the state's preeminent authority on the code. I arrived at the law school at this old building in 1965 and first enrolled in a Shanker class, sales, in 1966, the fall of my second year. Because of my interest and because he was an excellent teacher, I took 3 more of his courses over the time I was in law school, 1 each term until graduation. As a teacher, he was able to apply his years of experience as a practitioner to the analysis of the new code. He had seen what a thicket the prior commercial law was, and he welcomed a new approach. He enlisted us, his students, in the study of how the code changed prior law. Because there was then little case law interpreting the code, he had us read pre-code cases and consider how the new statute would apply to those fact patterns. He insisted on class attendance and preparation. He called on students who returned after missing some classes. When a student was unprepared, he used the student as a blank slate, as he sometimes did with his family around the dinner table. Jamie can probably verify that. I vividly recall being selected one day for a discussion of a particular code section, one I had not read. He worked his way through the section, which had several subsections, asking me a series of hypos. I guessed right a couple times, but with respect to several subsections, he said, I would have been right under the common law or under the prior statute. But unfortunately, he said, I had not read the particular subsection that would change the outcome. He was demanding in class, but he was never unkind. During the time I practiced at Legal Aid, I did consumer cases and some bankruptcy practice. My law school experience with Professor Shanker prepared me well for that. Because he embraced the change brought about by the code, he opposed the development of strict liability and tort. The code was drafted by eminent scholars like Llewellyn, Gilmore, and others. It was designed to be flexible and to be adapted to change by judicial development. He published an article in our Law Review in 1965, arguing that the goals of strict tort could be achieved by interpretation and amendment of Article 2 of the Code without what he deemed to be unintended and undesirable consequences. He lost that battle to Traynor, Wade, and Prosser. In a later article, he said that the debate had provided opportunities for scholars, but seems only to have brought about an enervating, costly, and confusing word game, which hardly was worth the effort. When I returned to the law school to join the faculty in the new building, I discovered that our colleagues called Professor Shanker Maury. It took a while for me to do that, but he welcomed me and was eager to assist me when I began, after a few years, to teach some of the courses he had taught me. Although he enthusiastically embraced the change brought about by the UCC, he did oppose change for the sake of change. When the Uniform Law Commissioners promulgated a major revision of Article 2, he opposed it, along with both consumers and business interests. That revision failed. It was never adopted anywhere. Maury was not alone in believing that the drafters of Article 2 had created a flexible statute that could be adapted and modernized by judicial interpretation and a few minor amendments. The first few times I taught sales, I had to deal with both the existing Article 2 and that proposed revision. I saw that Maury was right about the revision, as he was on so many issues. As students, we used to say that on controversial issues, there was a majority view, a minority view, and a Shanker view. The Shanker view was always well-reasoned and often the best. When I began to teach the course on Article 9, personal property security, Maury again offered assistance. I discovered he was right about another revision of the code. The new version of Article 9 which was adopted as I began to teach the course, was a wholesale revision of the original version. It included necessary modernization, but went far beyond that. It made Article 9 much longer, more complex, more detailed. It created lots of the dreaded unintended consequences. As a faculty member, Maury always argued against the unnecessary proliferation of courses. He advanced his conviction that our principal job was to prepare students for the real world of law practice. In faculty meetings, business often expanded to fill the time allotted. And as others have said, those unproductive discussions tested Maury's patience, so that when the meeting began to run down, the dean could always count on Maury to offer his motion to adjourn. On that note, I'll end my comments and yield the floor to the next speaker. Thank you for allowing me this opportunity.
Thanks so much, Bill. Our next speaker is Judge Marilyn Stoneham, who is a retired bankruptcy judge and a former student of Maury's.
Thank you very much, Sharona. And hello to everyone. It's really wonderful to be part of this celebration of Professor Shanker. And I'm bringing two different perspectives. One, the sort of maybe 50,000-foot view from the national bankruptcy community, and the other, the worm's eye view of a student in his class who didn't go on to become a professor. Professor Shanker's overarching talent was his ability to critique the deficits in existing statutory systems. He first displayed that talent as a member of the American Law Institute in its work reassembling a quilt of uniformly enacted state laws, some dating back to the 1890s. And they were quilted into the Uniform Commercial Code. And his focus was, of course, on Article 9. As we know, no good deed goes unpunished. So what's the acid test for secured transactions? Bankruptcy, of course. Thus, starting in 1964, he accepted the additional gig, first as an assistant reporter to, and then as a member of the Advisory Committee on Bankruptcy Rules of the United States Judicial Conference. This committee drafted rules that were then promulgated by the Judicial Conference. The significance of this work comes into sharpest focus when one notes that from 1964 until the effective date of the Bankruptcy Code in late 1979, Congress took the unprecedented step of providing that in conflicts between the bankruptcy rules and the 1898 Bankruptcy Act, the bankruptcy rules would trump that 19th century Bankruptcy Act. The Rules Committee was identifying the most needed updates to the US bankruptcy laws and enacting those changes through rules until Congress could get around to agreeing on what form the new bankruptcy law should take. So this was an extraordinary short-term bandage. And thus, from 1965 through 1976, Jamie, your father was a stealth legislator. The court-centered bankruptcy processes had numerous critics, some of the loudest calling for moving to a bureaucratic approach outside of the judicial branch. Given that the committee had been appointed by the US Judicial Conference, its momentum was focused on courts, arguably tilting toward the 1978 Bankruptcy Code's continuation of courts overseeing US bankruptcy processes. As somebody who later became a bankruptcy judge, I was very grateful for that decision. In the course of all of the pro bono activity, Professor Shanker became a member of the National Bankruptcy Conference. Being invited into the NBC is the highest honor that can be bestowed upon a member of the bankruptcy community. Though the invitation imposes considerable responsibilities. The NBC limits its membership to approximately 75 academics, judges, and practicing lawyers. The NBC analyzes any proposed changes to the federal bankruptcy laws and offers its considered judgment to Congress. At least in the first decade after the new bankruptcy code became effective in 1979, any suggestion of amending the code would get no traction in Congress without the NBC's Neil Opstadt. In 1974, as a second-year student, I enrolled in Professor Shanker's secured transaction course. Then I had no inkling of the rock star status, of his rock star status in the world of commercial law. Rock star, you say? Isn't that a bit of hyperbole? Well, no. Let's look at the evidence. Most rock stars have their own stylist. Professor Shanker had Mrs. Shanker. She was always tailoring these truly unusual pieces for him. I don't think anybody can forget the teal sports coat. I tried to find a shade to match that today. This was the best I could do. But beyond that, he presented in class with the certainty of a rock star who had internalized every syllable of his material. Professor Leatherberry's already noted the fact that you didn't just get the majority and the minority view, you got what should be the proper view, the Shanker view. So much more could be said, but let me simply note that the memory of the knowledge that Professor Shanker imparted was a blessing to me and so many other case students whose careers ultimately centered on commercial law. So Jamie, thank you for sharing your father with us.
Thank you so much. I am now going to read comments from Ms. Judy Call. She's a retired Case Western Reserve University law librarian, and she couldn't be with us for medical reasons. When I first started working at the Case Western Reserve Law Library, I had the good fortune to be assigned as the reference and research librarian for Professor Shanker. In addition to providing reference and research, I also supervised the AV recording of classes, lectures, and special events that occurred in the moot courtroom. Professor Shanker had all of his classes taped at that time. Eventually, the law library hired Jamie Shanker to take over the videotaping supervision between her undergraduate and graduate studies. Professor Shanker was one of the faculty members on the cutting edge of the use of video recording in the classroom. In 2019 to 2020, Stan Wanicki converted over 100 of Maury's video recordings to digital format. Andy Dorchak recalls once checking for Maury's publications available via Hein Online. He found that he had publications throughout 5, maybe 6 decades, many in great journals. Maury was a great supporter of the law library, and we encouraged him to stop by whenever the library was having potluck lunches or snack breaks. That is how many library staff members got to know him, and we made sure to always include him if we had a food opportunity. He seemed to like getting to know all of us over the years. He was always kind and appreciative. We all recognized that he was an important and brilliant scholar and obviously an expert in his field. Therefore, we were especially touched that he took the time to get to know us. He was kind in so many ways. We picked up on his love of music because he had 2 season tickets to the Cleveland Orchestra Friday morning concerts. And if he could not use both tickets, he would often share one or both of them with us. I have particularly fond memories of discussing the orchestra with him throughout the years. He would ask about my family and share how proud he was of his family. He told me about the reading program that Brandy designed in the Cleveland Heights school system when I mentioned that my son started attending elementary school in the district. He also shared that Brandy had done the rubbing from a British judge's monument in London that she donated to the law library. I think it still resides on the 3rd floor of our law library. When my father passed away, Maury asked about him. When told that my father served in the Navy in World War II, he shared with me his experiences in the Navy during the war. I remember that he showed me a picture of his group of officer candidates marching in white uniforms. Renowned for his skillful teaching, several times I overheard students discussing his classes, and they said that he was a great teacher who made a difficult, complex subject more understandable. One of my last interactions with Maury was when he was retiring and requested my assistance organizing material from his office. One day during this process, he was excited because he had learned that one of his articles had just been cited by the Ohio Supreme Court. It made him extremely happy during that bittersweet time of his life. I appreciate this opportunity to honor a great professor and a kind person. It was an honor to have known him and assisted him in his great work for this institution. We will now hear from Mr. Tom Hefferman, who's an attorney and former student of Maury's.
Thank you, Professor Sharona. I appreciate the opportunity here. I have something special in common with Professor Shanker. We both started at the law school in 1961. He as a law professor and I as a student, although he certainly stayed a good deal longer than I did. In fact, as Dean Michael might have mentioned, he may have set a record. He prepared us for what was to be Ohio law when the Ohio General Assembly passed the legislation adopting the Uniform Commercial Code into Ohio law in 1962, as Will Leatherberry had mentioned. This was newly codified law, which gave him the opportunity to make constant comparisons with the common law and with the accumulated case law, and gave us a much better understanding of the Uniform Commercial Code. Back then, and perhaps today, Case Law School gave us a broad classical legal education rather than a legal toolbox of what to do. While Professor Maury honored the philosophy of the school, he also wanted to prepare us for the real world of the practice of law in this area. We knew then that what he was teaching was the real thing. Now you contrast that with my real property professor, whose name will go unmentioned, who delighted in teaching about property law in the Middle Ages, as well as how to correctly measure property tracts and parcels on the surface of the moon, even though no human landed there until the late 60s. Such legal information did not lead to billable hours. It is a dirty little secret at all the good law schools that there is a systemic and purposeful overburdening of assignment material to be covered each night in preparation for the next day's classes. So, due to the limitation of the 24-hour day, it was often impossible to be fully prepared for each class. All faculty members, of course, would deny this, but you were always certain to be prepared for Professor Maury's class, not only because he was demanding when it came to his students being prepared, but because you wanted to learn his stuff. What he taught was well taught. and his students respected him for that. I spent 25 years as a plaintiff's personal injury trial lawyer, never having consciously used the Uniform Commercial Code. But as a second career, as a trial lawyer with the firm of Thompson Hine, I defended cases far afield from injury. One of those cases, which ultimately went to trial, was a business case that involved some fairly complex Uniform Commercial Code issues. And while I led the trial team, we did have members who were conversant with the Uniform Commercial Code. But as we reviewed the case issues, I was amazed at how much of the Uniform Commercial Code I had retained from Professor Maury's course. Of course, it required a little dusting off, but it was still there. Believe me, this is not a paean to my retentive powers, but rather a tribute to the power and force of his teaching skills. One final story about that case. When we went to a pretrial in-chambers hearing to resolve some of the legal issues to be confronted, we went before a judge who we knew was not going to be the trial judge. I was impressed with her vast understanding and grasp of the Uniform Commercial Code issues that we put before her. And today, as I think back on that hearing, in her astute facility with the Uniform Commercial Code, I can only conclude that she too must have been, and probably was also, a student of Professor Maury Shanker. May he rest in peace. Thank you.
Thanks so much, Tom. Next, Mr. Michael Shapiro will give us comments. He is also an attorney and former student of Maury's.
Yes, thank you very much for this opportunity to speak today. In the summer of 1992, I took a sales class from Professor Shanker. And I remember on the first day of class and on the first question, I don't remember the question, but he asked me a particular question, called on me. I gave him an answer. He accepted the answer. And then he said, when I asked your father this question in 1961, his answer was, and then recited my father's answer from, many years before. My father had been in his first class when he had started at the law school. Professor Shanker was a memorable and important influence, both for my father and for me. My father kept his notes from Maury Shanker's class his entire life. It was in a gray box in our basement. I attended CWRU Law School from 1991 to 1994. And there were a lot of outstanding professors who I had the opportunity to take classes from, but very few of them would I classify as truly inspiring. And Dean Peter Gerhardt would have been one, but Maury Shanker was definitely the other. In addition to the sales class, I remember taking a property security class from him that focused primarily on, Article 9 of the Uniform Commercial Code. And for my last 2 years of law school, I took mostly code classes, either Internal Revenue Code classes or Uniform Commercial Code classes. And I remember joking with him after a class one day that I do better with classes that have a code that I can live by. I remember discussing his theories of law school, and that's something that I know a number of people have brought up. But he was very clear that his goal in law school was not just to teach us how to think like a lawyer, but to also teach us how to be a lawyer. And that was important to him. And he was something that he was sharing even with students, even though it was not a uniform opinion among the faculty. When I was talking to him after class one day, I also learned that he had attended Shomrei Shabbos congregation on 105th Street in the Glenville area when he was a teenager. And the head rabbi at that time was my great-grandfather. And what I found so interesting was at that moment in time, he was the only living person that I knew who had met my great-grandfather. I also worked for Professor Shanker from time to time during my second and third years of law school. I remember going with him to a labor arbitration where I picked him up. I drove him to the labor arbitration. I took notes. I then discussed the case with him. He asked me questions. He wanted my opinion of the result. I gave him what I thought the decision should be. He completely ignored everything that I said. And then I realized that my job here was just to drive him back and forth. But it was still a pleasure to be able to see how he thought and how he worked. During the arbitration, instead of having the company, it was a labor arbitration, instead of having the company pay for our lunch, he insisted on paying for the lunch himself. And then he billed the company for the cost of the meal. And I indicated it's all circular. I mean, it's going to be paid by the company anyway. Why not save the time and the energy to just have the company pay for it up front? And he explained that the appearance of impropriety, even though there was no impropriety that would be going on, was important enough to do the circular process of paying for it and then submitting it for reimbursement. And that was a very important lesson in practical legal ethics, that I've never forgotten. I did talk to Professor Shanker from time to time after I graduated, even at Stone Gardens. But a more memorable conversation I had with him was in 1998, after the revised Uniform Commercial Code was passed. And we were talking about the changes, and he was very excited about most of them, particularly the centralized filing, where the vast majority of filings could be done in one centralized location. But he cautioned me that you have to remember there are a couple things that aren't filed with the Secretary of State's office or whatever the centralized filing is for the state, fixture filings and filings on growing crops, which I thought was a funny concept for a lawyer from Cleveland, Ohio. It took me 20 years, but I was working on a transaction where the company that the loan was being made to also had a tree farm, and I got to file a UCC1 financing statement with the county on growing crops, the one and only time in my career. Professor Shanker consistently exhibited brilliance, a commitment to teaching, commitment to the practice of law, and decency in every interaction that I ever saw with him. And he will be missed. Thank you.
Thanks so much. Our next speaker is Professor Ken Davis. He is the former dean and now a faculty member at the University of Wisconsin Law School, and he too had Maury as a teacher.
Thanks for including me. While I didn't get to know Maury as well as many of the rest of you, I may have the distinction of knowing him in the most capacities. First, as a student, he not only taught me secured transactions, but along with Leon Gabinet, he was my very first law school dean in a year in which they faced mind-boggling challenges, not the least of which was how to move an entire law school across Euclid Avenue over the course of a single weekend midway through the semester, and somehow they pulled it off. He later hired me, like Mr. Shapiro, as a research assistant, this time for a commercial arbitration. Later still, I was briefly his faculty colleague. And then finally, there's the capacity on which I want to focus my remarks, as Maury's editor. Our law review board received a submission on breach of contracts damages in what was known as the lost volume seller problem. We ran it past Professor Shanker, who recommended we publish it, and also said he'd like to write a rebuttal. When we got his manuscript, we attacked it with the zeal not uncommon to student editors, which earned me a summons to Maury's office as soon as he saw our result. He recounted a conversation he'd recently had with a colleague at another law school over their mutual frustration with the editorial process, and then laid down the law. If we wanted the piece, we took it as is, which we did with two consequences. First, the piece is far better. Rereading it today, all these years removed from his classroom, I'm still struck with how Maury's scholarly voice so mirrored his teaching voice. No purple prose or theoretical or elaborate theorizing. Instead, lots of concrete examples and illustrations, a reverence for what the statute says, occasional bits of Socratic questioning, and liberal use of humor that borders on what today we call a dad joke. As for the second consequence, I can't remember the details of that conversation Morrie had with his colleague. What I do recall is how Morrie used it to turn a tension-prone encounter into a teachable moment. And I came away with a fresh appreciation for the author's perspective and what our role as student editors should be. When I've occasionally tried to impart to those editing my own work, but never as skillfully or as successfully as Morrie did with me. There's one more part to the story, however. This was the very beginning of law and economics, and part of Morrie's thesis was an economic one. I was armed with all the expertise conferred by an undergraduate course or two in microeconomics, so I proposed to Morrie that his analysis should be taken a step or two farther. I mean, you can imagine how that probably was received. So when Morrie disagreed, I did what now strikes me as cringeworthy and published my ideas as a separate postscript to his article. Volume 24 of the Case Western Reserve Law Review, if any of you are interested. I say cringeworthy not because I did it, I still think the ideas were pretty good, but how I did it. In complete ignorance of such basic scholarly courtesies as alerting him to what I was doing or giving him a draft for comment. I think I just sent it off to the printer. Was Morrie irritated? He never mentioned it, so I'll never know. But after 14 years as a law school dean, I've certainly known faculty to take offense at far less. Though I'd like to think that by that point in his career, his accomplished career, Morrie was willing to shake his head and write it off to a variation of boys will be boys, what some have described as editor-in-chief syndrome. What I can say is that if he was irked at the time, he was incapable of harboring a grudge over it for 20 years, which again separates him from many in our profession. When I returned to the law school in the mid-90s, excuse me, for a one semester visit, no one was more welcoming and gracious than Morrie and Brondi, rescuing me from the lonely confines of the Alcazar Hotel to host me at their home and at the orchestra. That's why whenever I'm sitting at my desk, steam coming out of my ears over what some third-year law student has done to my prose, on my better days at least, I try to think of Morrie and cut the kids some slack. Thanks.
Thanks so much. Now, Dr. Irv Kushner, who is a professor emeritus of medicine at CWRU.
This is a law school event, and I'm sure you understand that I don't know much about his academic activities. I do know that he was an international authority on bankruptcy and commercial law. But I'm an academic, and my approach when I'm scheduled to give a talk is to go to my reliable friend, Google, and see what I can learn about my subject. So I did that with Morrie Shanker. The first thing I learned was that he was, in his realm, a very original thinker. I learned that in 1968, he published an article in the Georgia Law Journal in which he suggested that law students be required to take graduate courses in other departments of the university and to relate that learning to the law, that it be a requirement which the law students would have to fulfill in order to get his law degree. I should say his or her law degree, shouldn't I? Without this broadening of horizons, he felt that our legal system may lose contact with the society it exists to serve. I learned that he had published an article in the National Law Journal in 2006, arguing that our Social Security laws be changed to encourage our older workers to continue to work, that we ought to repeal the requirement that the benefits received by Social Security recipients be taxed. A great idea. I learned that an article he had published in 2003 entitled "Will Mortgage Law Survive?" was cited in the Florida Bar Journal in 2020. I can only guess what that was about. But Google failed me in one regard. I couldn't find a column by George Will, who knows how many years ago, in which he referred to an article by Morrie. Maybe some of you can remember that. But now, on to Morrie's personal qualities, the man himself. Of course, I knew Maury best as a human being, as I'm sure you all did. It was rewarding for Enid and me to be included for many years in the warm, welcoming social circle revolving around Bronte and Maury's home. As we all know, he was gentle and unassuming with a kind and generous heart. My personal experience, he perceived that I was in need of guidance when I was seeking an appropriate Jewish congregation in which to say Kaddish after my parents died, and he steered me to Congregation Bethel. I'll end up with the most interesting item I found on Google. Some of you may think it belonged to the portion of my talk related to academic issues, but I prefer to think it belongs here. This is from the February 21st, 1964 issue of the Detroit Jewish News. I'll quote, "The B'nai B'rith Hillel Foundation at the University of Michigan will hold its annual Purim debate 8 p.m. Thursday at the conclusion of the reading of the Megillah. Presented in the spirit of a panel of faculty members, half advocating the merits of the latke, potato pancakes, the other half of the hamantash, the triangular filled pocket cookie. The subject is the latke, the hamantash, and civil disobedience in an ecumenical age. The debaters include, as latke proponents, Myron Simon of Detroit, lecturer in English at the Dearborn campus of the university, Dr. Morris Shanker, visiting associate professor of law, and Dr. Caesar R. Blake, assistant professor of English. I was particularly pleased to see this because I participated in a similar debate in Cleveland about 15 or 20 years ago, and I also spoke on behalf of latkes. Thank you for the opportunity to speak today.
Wonderful, thank you. And if you might want to adjust your screen, we're not seeing your full head.
Tilt your head. I'll fix it. I'll fix it.
Okay, we got it now. So great. We are now going to hear from Dr. Kushner's wife, Enid Kushner, who is an attorney and also a former student of Maury's. Oh, and you're muted. You need to unmute.
Unmute, Enid, unmute.
Okay,
There we go. Thank you.
perhaps I, of all the speakers today, have known Maury the longest. I first met him when he returned to Cleveland shortly after his graduation from law school at the University of Michigan in 1952. I have a picture of the two of us in the early 1950s when we were about to go on a date, and I was an undergraduate at Flourstone Mather College. Unfortunately, I am now in Sarasota and the picture is back in Cleveland, or I would have shared it with you. I really don't remember the occasion, but I'm sure we had a pleasant time. Once he and Maury and Bronte were married, we were privileged to be part of their salon, an assemblage of interesting people that they attracted and entertained. We shared many enjoyable meals and interesting conversations around their dining room table. Maury and Bronte were always interested in our children. My son Philip graduated from the University of Chicago Law School in 1985. Toward the end of his final year, Irv's father died. Philip went to New York for the funeral just at the time of final exams. After he returned to Cleveland, Maury volunteered to proctor his taking his law school exams that semester. Philip thinks that Maury always took credit for his graduating law school, and indeed he deserves the credit. Of greater significance is his impact on my legal career. I did not decide to go to law school until I was in my 50s. The CWRU Law School accepted me. As graduation in 1986 drew near, I was trying to decide what limited area of law I should specialize in, since I would not have a long enough career to learn what was needed to have a general practice. A newly appointed federal bankruptcy judge, Judge Randolph Baxter, approached Maury for his help in finding a law clerk. Maury suggested me. The bankruptcy laws were changing in 1986, so I took a quick, intensive course on bankruptcy given by Maury Shanker and remained Judge Baxter's law clerk for 3 years. Those were the best 3 years of my law career. Following that stint, I was able to get a job with a firm specializing in bankruptcy, so I owe my whole law career to him. In sum, both socially and professionally, I go back a long way with Maury Shanker. When we would visit him in Stone Gardens, we still saw the same warm and interested person he had always been. It was a pleasure to know him.
Thank you so much. This was a wonderful, moving tribute, and I certainly learned a whole lot about Maury Shanker that I did not know. Thank you to everyone who took the time to compose these comments, and thank you to everyone who attended. I believe the law school will be posting a recording of this along with written versions of the comments. Dean Scharf, where will this be posted? Do you know?
Well, they'll be posted on our website, and we'll send an email out with the link to everybody here.
Wonderful. Be well and have a good evening.
Bye, everybody.
Thank you so much. Eric, see you soon. We're coming to Cleveland on Saturday.